case on this morning's docket. That is case number 106680, State of Kansas v. William Jolly.
May it please the Court, I'm Janine Cox, Deputy Appellate Defender. I represent William Jolly on this state's appeal. Your Honor, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Just a little procedural background. This is the second time the case has been before the Court following Mr. Jolly's appeal from his first sentence imposed by the District Court. This Court found that the District Court had improperly departed to the grid by imposing a sentence outside the appropriate grid box and remanded the matter for resentencing. District Court again departed to the grid, imposing a sentence in the appropriate grid box. The state appealed that sentence. Court of Appeals assigned this case to a summary calendar docket, and on November the 9th issued an opinion reversing the District Court and remanding for resentencing. Court of Appeals opinion consisted of a majority, a concurring, and dissenting opinion. One I've never seen before, I think, in all my time. Mr. Jolly filed a petition for review with this court, and on October 4th, 2013, this court granted the petition and ordered the parties to file supplemental briefs addressing whether it is appropriate for a district court to consider aggravating circumstances in considering a departure from a Jessica's Law sentence under 214643D, and if so, the method and manner in which those circumstances should be considered. So unless the court wishes to go in a different direction, I would address my comments to that request.
Counsel, for the benefit of our spectators, could you spend about a minute or so just kind of outlining what the charges were, the convictions, that sort of thing, to put this in context?
Yes, it's so far removed from my position in the case, but generally speaking, it was a Jessica's Law case, which is a case involving inappropriate sexual contact with a minor. The sentence in that case, unless a departure is granted, results in a life sentence without the possibility of parole for 25 years.
Thank you.
Okay. The question that this court posed was whether or not, under the statute, it is proper for the district court to address, when considering a departure motion, consider aggravating circumstances. I start with my first point, and the very first part to begin is the language of the statute, and this is 214643, where the statute reads, the sentencing judge shall impose the mandatory minimum term of imprisonment provided by subsection A, which is the 25 life sentence with no possibility of parole for 25 years, unless the judge finds substantial and compelling reasons following a review of mitigating circumstances to impose a departure.
And that departure is downward. There's no place to go.
There's no place to go. We're talking about a life sentence. The only place to go up is a death sentence, which obviously this is not a part of a capital case.
And we've already determined that the legislature has essentially found the aggravated circumstances in the whole area of these criminal acts.
Under this statute, because there is no place to go, there is no way to intensify, there is only a way to go down, the legislature has decided that these cases are of such a nature that the ultimate penalty, short of a capital case, will be imposed. This statute, unlike other statutes, when we're looking at departures, only refers to mitigating circumstances, does not refer to aggravators in any way, shape, or form. Under departure sentence under the guidelines on 4617, there are aggravators and mitigators both in the statute, and under the capital case, the same thing is true. There are aggravators and mitigators.
Ms. Cox, excuse me.
Yes.
I understand the word aggravating, mitigating have significance within the statutory scheme of sentencing, but can't aggravating also be considered totality of the circumstances of the case, the heinous nature of the case? I mean, not all Jessica law cases, they're all bad, but they're all different too. And isn't aggravation just another word for considering the facts of the case? And if that's the case, and you may not accept that, but if that's the case, isn't the sentencing judge duty bound to consider other factors to mollify the issue of mitigation?
First of all, I don't believe any judge makes a decision on a sentencing in a vacuum. We all know that. But I think this statute is very specific about what the judge is supposed to do. The judge is to review the mitigating circumstances. The aggravators have already been there, and the judge knows that. I'm not saying that's not in the equation, but it's not in the equation in a weighing factor that it is in under the sentencing guidelines or it is in a capital case. I'm not saying that a judge simply, blanks out anything that's happened. But what the judge is compelled to do by the statute, and the legislature knew the language of putting in mitigation and aggravation in statutes. It knows how to do that. It clearly chose not to do that in this case. And part of it is because what we mentioned before, this is already as far up as it can go. It can only go down. That the judge is to review the mitigators, and even if there are mitigating circumstances, the judge does still not have to grant the departure.
Mitigation doesn't equal substantial and compelling.
No, it does not. It simply means the mitigators. I would point to Judge McEnany's dissent in the case below when he talks about what might be one, and maybe it's semantics, but it seems fairly clear that the legislature had a distinction here. That perhaps in reviewing mitigators, evidence could be brought in to show, well, that's not really a mitigator, and therefore it wouldn't fall into a category to go into the lump of something that would be considered substantial and compelling to depart.
Or they can argue that it's not compelling because of the egregious nature of the crime.
It's not compelling. And if you look, and I admit I did not do a completely exhaustive review of all of the cases, but if you look at the cases where we've addressed Jessica's law departures, and might I say that the vast majority are those where the departure was denied, and this court has upheld that denial because, as you recall, your standard of review is an abuse of discretion standard on that. And that cuts both ways. If the abuse of discretion standard says that no reasonable person would agree, not one reasonable person would agree with the court's decision, the district court's decision. And in almost all cases, you have found that the court did not abuse its discretion.
Some reasonable person out there would agree.
Yeah.
Yeah, the real problem here is just that we've been somewhat inconsistent. I mean, we have, and then perhaps sentencing judges need to be mindful to always put their language in mitigation form as opposed to something else. I think we're all talking about the same thing.
I think that's correct. And I went back and the first case I looked at, I started looking to see where did we start talking about mitigators and aggravators in these cases, and I found references back to cases that didn't have anything about aggravators in it. The Ortega Calderon case is one of the first ones that started. I think Spencer tried to lay out pretty clearly what our standards of review were, and also
Spencer was the first one that tried to get a handle on the tsunami of Jessica law.
Yes, I think and this happens to us frequently when we have McAdam comes about or Murdoch's rolling down the road right now. We have these where we have a large number of cases that are coming through.
Radical evolution.
I'm sorry.
Radical.
Yes.
Revolution.
But as I looked through the cases, there were numerous cases. Spots is one, and these are cited in my brief. Plotner talks about the two-step analysis that a district court is to perform in deciding, and the first of that step, you review the mitigators and then make a decision whether it's substantial and compelling to depart. Then when we get to Salinas and Baptist, which was in 2012, the language of weighing aggravators and mitigators comes into the case law. And although there were a couple of cases after that didn't have the mention of aggravators, the change in that and the way to look at that makes it difficult to align with what the statute says what the statute requires.
Let me inject a little bit. I just want to,
Okay.
and let me lay it out the way I'm thinking, and if
Okay.
I'm wrong, tell me.
Okay.
I think the first point is our court and other courts have been inconsistent in our terminology, like Justice Beyer says. So I think we've created a little bit of this semantical problem. But that aside, the district court, number one, considers whether any mitigating factors exist.
Correct.
Step two, does that mitigating factor or factors substantially compel a departing sentence? And in the calculus of deciding whether you're substantially compelled to depart, includes the circumstances of the case. I don't want to put aggravating,
Right.
mitigating, just the circumstances of the case.
Right.
And so if we say it that way, which is kind of what I'm inclined to do, is that okay from your perspective?
That's closer to what I think the legislature meant and what the statute means. The Florentine case, there was still some talk about aggravators in that case, but it talked about I'm trying to get away from this weighing thing because I think that's not what this statute says, because we have weighing in the other statutes. Is looking at the mitigators against the norm that's been defined by the legislature, and that's the language. The norm defined by the legislature, circumstances inherent in the crime and the sentence. And part of that comes back to what we talked about in terms of the statute itself. And the fact that the legislature has taken into consideration the heinous nature of these crimes.
But that's where I'm trying to get at, though.
Okay.
Is this language about the seriousness of the crime, because that I can read into that child sex crimes are bad. All child sex crimes are bad.
Correct.
And so that's the norm. And I'm trying to get to the circumstances of the case. In other words, if a particular case has long-term, a long period of time where the abuse occurred, that's specific to that particular crime, that circumstance, I'm not trying to call it an aggravator, I'm just saying that circumstance gets considered by the district court in determining whether there's substantial and compelling reason to depart. I'm trying to make a difference between just a generic classification of child sex crime and the specific circumstances of the case. Am I wrong in trying to word it that way?
They're all different. There is no question about it.
I don't care about what the past case is. I'm trying to say for
No,
the rule that we're going to set
Go
down,
forward.
does that cover it for you? Is what I'm getting at.
It's closer to where my position would be than talking about weighing and
Sure.
Aggravators and mitigators. I think that's closer, and I tried to say that when I was speaking with Judge Malone about. I don't think a district court ever blanks out and doesn't consider the circumstances. I do think.
Excuse me, do you quibble with our case law that says, that defines compelling, that it implies that the court's forced by the facts of that particular case to leave the status quo and go beyond what's ordinary, that brings the facts of this case into play?
I mean, clearly that's true in, all sentencing departures cases, and that language is there. And I probably would have less of a quibble with that than I would with the others. The bottom line, and I see I'm out of time, the bottom line, and I do want to say something about this case because there is an actual case here where a departure sentence was granted and then the Court of Appeals has sent that back for resentencing. The bottom line in any of those cases, if we were talking about departure, is there's an evidentiary test, whether the record supports what the district court says as its reasons, and then the legal test of whether no reasonable person would agree with what the district court did. In this case, for Mr. Jolly, the court stated its reasons on the record. They had to do with no criminal history, acceptance of responsibility by pleading guilty, and that's clearly always been a factor that you consider as taking responsibility. And then Dr. Barnett's report, although there was some discussion about Dr. Barnett's report, but the district court very clearly on the record stated...
Well, that was the fly in the ointment. I mean, Dr. Barnett was dealing with maybe some untruths in his evaluation. And
he was dealing with what almost every psychologist or psychiatrist deals with, and that's the self-report of an individual who is being evaluated. But he also made recommendations and came to conclusions on other things. So that report was there. State didn't object to Dr. Burnett as an expert, didn't object to the introduction of the report or his testimony.
They cross-examined him
him
on the truthfulness of the self-reporting.
It was all there.
So the
yes.
district judge had all of that before the judge when the judge made the determination.
Exactly.
And used that for so the judge made a credibility determination of the value of that report.
Which is what a trial judge does. That judge is the fact finder.
And the Court of Appeals, as I read it, a large part of the majority was that they found Dr. Barnett's report not credible.
Right, but that's not the Court of Appeals' role in our system. So
your answers really go into something that's bothered me about much of the discussion today,
okay.
which has been a focus on the crime and the circumstances of the crime. And maybe again, this is just a matter of semantics, but don't we also have to focus on the characteristics of the offender? I mean, 214601 gives us a general statement about how we go about sentencing and says that the trial court shall look at the individual characteristics, circumstances, needs, and potentialities as revealed by case studies. And isn't that much of what Jessica's Law is about? And also, isn't that why we really have the departure in this case that we have? Because it was the trial court focused on Mr. Jolly and his characteristics, not so much the heinous nature of the crime.
I think you're correct, Your Honor. I think that is true, and that is what a trial court is supposed to do. And a trial court is in the position to see, hear, evaluate. We're looking at a cold record, and you all know, and certainly I know over all these years, what's on the cold record sometimes is not exactly what occurred. But you're exactly right. And in this instance, the judge, based on all of the information and listening to all of the evidence, made the decision that there were substantial and compelling reasons to depart. And an appellate court, and the record supports that. There's evidence in the record to support that. And an appellate court's only decision then, under an abuse of discretion standard, is to determine that no other court, no other judge, no one else would come to the same conclusion. I suggest that this court and the Court of Appeals before it could not do that, and I would ask that the Court of Appeals decision be reversed and the district court's departure sentence for Mr. Jolly be affirmed.
Counsel, before you sit down,
Yes.
I want to go back to perhaps a hypothetical.
Okay.
Under your reading of the statute, at the hearing where the defendant puts on the mitigating circumstances, and there are some illustrations of those in the statute itself,
Right.
is the prosecution's role at that hearing limited to just cross-examining defendant or putting on some evidence to try to rebut each mitigating circumstance, or can the prosecutor go further?
Actually, hadn't quite thought of that. I think under the statute, because the statute is so different than the other statutes where we talk about departures, where we have a list of aggravating circumstances. In 4617, I think it's non-exclusive, but it's clearly exclusive in capital cases. I guess just thinking of it here on my feet, I would say that is what the state is allowed to do, is to just address. I mean, certainly courts always ask for a summation. Anybody have anything else to say? And I suppose it could be the state could at that point put it, or at least make an argument on it. But given the nature of the question you asked me, I think that would be my answer, standing here right now, not having had very long to think about it.
And in a standard sentencing under the other statute you referenced, victims are allowed to testify, to talk about the impact of the defendant's actions on them.
Right.
Is there any place for that kind of evidence in the structure that you think is in the statute?
Well, it does come in because the victim's relative of the victim in this case did testify. And so there's still, so perhaps thinking of that, maybe what I said boxed me in too much for that, because there were victim statements. And there are victim statements that come in.
And that is allowed and proper
allowed.
Under your reading of the statute?
Well, it's allowed, and I hadn't thought about it in any way. I was just going along with the normal structure that we do, is that we allow victims to testify.
Well, the reason I ask that is there seemed to be some comments today, perhaps they were just teaching moments, that would suggest a clear reading of the statute means if it's not a mitigating circumstance, it's improper for this hearing. And I'm trying to nail down if that's your position or what.
I'm not. No. I guess I'll backtrack a little bit. I've kind of boxed myself in, and now I'm taking myself a bit out of the box. I think the language of the statute, after review of the mitigating circumstances, that doesn't preclude there being other. That doesn't preclude there being other circumstances, as we talked about the whole nature of the case, and perhaps the victim statements would fall into that ballpark. But it's the decision is after a review of the mitigating circumstances. And maybe I'm quibbling here and not giving a bright enough line here, but I don't think we could ignore that the court's decision is made after the review of mitigating circumstances.
And we misstate, I think, a lot what the statute says. It doesn't say that the court shall state its mitigating circumstances.
No.
Actually, it says that, as you said, following a review, it'll determine whether to make a departure, and that the judge shall state on the record at the time of sentencing the substantial and compelling reasons for the departure, and I see no reason why the state can't present evidence and litigate and advocate for no substantial and compelling reasons.
Right. I think that's right. Not taking that next sentence in there kind of cuts it off in a way that probably is not intended. But the statute is different. The statute is different from every other sentencing departure statute there is. And that's the distinction. Again, in this case, the district court made proper findings supported by substantial competent evidence I would ask this court to affirm the district court and reverse the Court of Appeals.
Thank you, counsel. Any further questions? All right, thank you.
May it please the court, Christina Trocek, Assistant Saline County Attorney, appearing on behalf of Appellant State of Kansas. Justice Biles, to first address your analysis, I think the state would agree with that analysis in considering Jessica's law and the application of mitigating circumstances. The court simply, and I would agree with Justice Johnson, the court reviews the mitigating circumstances, but ultimately the last thing the court does is to determine if there are substantial and compelling reasons to support a departure in that particular case. And I think that that is somewhat lost in the arguments this morning, because the state's primary position is that the facts of this case were so egregious that...
Ms. Tracy, on that point, was the evidence of the first sentencing concerning departure basically the evidence of the second sentencing when it was remanded?
It was, essentially.
And the state did not cross appeal the first time, did they? That the judge did not find substantial and compelling, or that the finding of substantial and compelling reasons was improper? I didn't see anything on that first appeal that would indicate that.
No, because it was pretty apparent early on that the sentence was illegal, and after the case was remanded, then I guess the state from that point on started from square one with that regard. And once it was remanded, the state's position with regard to the departure stayed the same, though, that there were no substantial and compelling reasons to support the trial court's decision or the sentence.
So you knew the trial court was going to be reversed the first time as a reason you didn't appeal the substantial and compelling reason finding?
I think the state had actually perhaps filed a notice of appeal, the defendant filed a notice of appeal, and the state proceeded on the defendant's notice of appeal.
All right, thank you.
Thank you.
But why wouldn't that be the law of the case?
Well, we never got to that point because the sentence was illegal. I guess that's what the way the state would look at that situation. The sentence
So
would,
it voids all findings that were relative to that sentence?
well, I think it does for the purposes of that sentencing. And the state does not contest that Dr. Barnett's report was again considered in the second sentencing hearing, but it was made very clear that the state objected to the conclusions that Dr. Barnett came to, primarily based on the fact that Dr. Barnett in the first sentencing hearing did admit that his opinions could be influenced by the fact that the defendant had not been truthful with him, especially with the issue of whether penetration had occurred, whether sexual intercourse had occurred. And he responded affirmatively that that may have impacted his opinion, but he didn't have the facts in front of him.
What does that mean to us when we have a trial judge that heard all of that, heard that witness be cross-examined, and made a determination of credibility and relied upon it and put it in the journal entry? What does it mean to us that you disagree with the efficacy of Dr. Barnett's opinion when the judge says, I accept that and find it credible?
The state's argument would be that regardless of the court accepting that opinion, it still does not support a finding of substantial and compelling reasons to depart. And again, I think that's where we lose a little bit, because that has been defined by case law, substantial and compelling, to mean something that is so compelling that it literally forces the sentencing court to go against the status quo. And the status quo here, of course, would be the 25-year to life sentence.
And do you think that is an abuse of discretion standard?
I do.
And so we would have to determine that no reasonable person would agree with the trial court. That would be our, of the different types of abuse of discretion, that's the area we're in.
I agree with that, and I understand that's a difficult standard of review for the state and the position the state's in this case. But the ability to appeal on the state's behalf when a departure is granted would mean nothing if we don't correctly apply what substantial and compelling really means. And what it really means is that something about, whether we want to say it's the character of the defendant, the facts of the case, something is so compelling that it would force the sentencing court to grant a departure in this case. And that's where the state disagrees, because there was nothing that could be considered so substantial and compelling to force the trial court to impose a departure sentence when we're looking at an adult male who admittedly engaged in what he described as a pattern of exploration, clinical exploration or experimentation with this young child who he knew had been sexually abused.
Let's be clear here. We're not looking at that. We're looking at the factors that the court found on the record, put in a journal entry. And I'll read it to you. Dr. Barnett found no evidence of antisocial behaviors, previous molestation history, mental illness. Therefore, the defendant is less of a danger to society. Defendant does not possess traits as a pedophile or sexual predator, end quote. Now, that's what we're looking at, not your characterization of the crime. We're looking at, is that a substantial and compelling reason to depart from the ordinary sexual abuse case?
But we're also looking at the circumstances of the case. It's the state's position is you can't consider it in a vacuum. If we did consider it in the vacuum, I perhaps would agree with you. But that's not what we do when an individual is sentenced, especially when the court is considering a departure sentence. The court should have the ability to look at the facts of the case, the impact on the victim.
And the court did, the trial court did that. We have no evidence that the trial court ignored the facts of the case, do we?
She really didn't mention the aggravating circumstances.
See, I don't think that's true.
And the second sentence.
And I don't think that's true. And here, I mean, correct me, but that's where I jump off here, because I went back and looked at the transcript of the hearing and all that, and the court makes very clear that it has considered all of your arguments, and you made all those arguments. Mm-hmm. So this isn't, I mean, the court had a full plate of information from which to choose what Justice Johnson's talking about. It chose in order to go forward. And so getting back to the abuse of discretion standard, I'm having trouble with your argument.
Well, the state still contends that she abused her discretion when you look at the facts of the entire case. You have to look at the facts of the entire case. You have to look at the impact on the victim, and the victim's grandmother clearly testified to that at the sentencing. You have to look at the intent of the defendant. You have to look at the fact that while the defendant said, and I know the court found that he took responsibility, the defendant characterized his actions towards this young girl as trying to help someone. And what does that get me? I've been in jail, and here I was trying to help someone. And the court did question that.
It's just, you're basically arguing there's no way a departure is appropriate in this case.
I am.
Just no way.
I am arguing there's no way that any reasonable person would feel compelled to grant a departure.
Given the facts of this case, there's just no absolute way that you can depart. That's your bottom line.
Help me with the record here on that. Was there any indication that the judge believed the second time around that I've already made this substantial and compelling finding, I'm bound to follow that finding, and the court has said I have to tie that in with some guidelines? But she already made a finding of substantial and compelling. That wasn't appealed. It was sent back to reconsider this, but there was no indication. Was there anything in her record? I don't remember indicating that. Well, that I found one time there's substantial and compelling reasons. I have to find it again.
Not that I recall. I know that the defense counsel did make an argument that the court could not impose a greater sentence the second time around, but I don't think there was any specific colloquy in the record by the trial court that she was bound to follow her reasoning or her ultimate conclusion in the first
But why
case.
wouldn't she feel compelled to follow it? I mean,
Well,
it goes back to my original
Right.
question.
And I guess from the trial court's perspective, the trial court really didn't give the defendant much consideration with the first departure other than essentially to give him the opportunity for good time credit. She tried to impose a sentence on the guidelines of 300 months, and my interpretation of that is to give the defendant a little benefit. And the state would submit that, of course, that was an illegal sentence, so court was not able to do that. But, and
Was
I
there
know,
any comment? I hate to go back to the first one.
No,
but
you're fine.
You've talked about that. Was there any comment at the time when that happened, Judge, that's an illegal sentence, we move to reconsider? At the original sentencing, I'm talking.
there was not.
Okay.
There was not. And to, I guess, reiterate the state's position, and I certainly don't want you to perceive this as argumentative, but the state's bottom line is that the language of substantial and compelling reasons to depart really loses its effectiveness if we're going to apply it to circumstances in a case like this. Quite frankly, the defendant's lack of prior criminal history, the acceptance of responsibility, whatever that was, by entering the plea and preventing the victim from testifying, as well as Dr. Barnett's ultimate conclusions, although based on inaccurate information by the defendant, still do not provide a basis to compel or force the district court to depart when you consider the totality of the circumstances in this case, when you consider that the defendant's actions forever altered emotionally, psychologically, the victim.
But wouldn't that
In
be
this
true?
case.
Wouldn't that argument be true of every child sex case?
Well, in this case, though, the defendant knew the victim had just been removed from her mother's house after having been a victim of her stepfather's sexual abuse, and this defendant decided to see how very truly damaged the victim was in this case, and that's why he engaged in the sexual exploration that he did in this case. So not only was he a trusted family friend, he knew her history of prior sexual abuse. He decided to take advantage of it without any regard to how much it damaged her. Yes, sexual abuse is damaging in any case, but in this case, when you have a defendant who knows of prior sexual abuse and takes advantage of it without any regard for how much that's going to further traumatize the victim, the state just is at an utter loss to understand how you could ever find, how a reasonable person could ever find substantial and compelling reasons to depart.
Didn't you just give that eloquent argument to the district court at sentencing? Just what you just did.
Well, I did, and obviously I wasn't successful with the court, and maybe I'll be more successful with this court.
And isn't your bone to pick with the legislature? I hear you arguing that these crimes are so egregious that there shouldn't be, if the victim is traumatized, there shouldn't be a way that there was any departure. But they specifically made provision for departure, and they specifically listed some mitigating factors that focus on the defendant, like no criminal history, committed while the defendant was under an influence of extreme mental or emotionally disturbances. That doesn't focus on the harm to the victim. So your complaint is with the legislature setting up a mechanism that this trial court followed.
It really is not my complaint, because I do feel that there are cases where it's appropriate for the trial court to depart from a Jessica's Law offense, especially those cases when you have a younger offender, maybe a 19-year-old offender who has had sexual intercourse with a 13-year-old girl. The state does not object to that type of finding of substantial and compelling reasons to depart. So I would disagree that my argument is with the legislature and how they have crafted this particular statute, because I do feel that there would be several circumstances where a finding of substantial and compelling reasons would be supported, even with statutory factors set forth in Jessica's law, as well as the non-statutory factors.
So how
Counsel?
would you articulate that standard of review to capture the limited circumstance? Here's what I wrote when I was reading your briefs and doing all this. And it's the same thing Justice Johnson just said. As long as the legislature gives district courts discretion to depart in child sex crimes, we cannot engage on appeal in a form of review that results in no child sex crime ever being eligible for departure because it's a child sex crime. So articulate for me the standard of review on appeal that we can use that covers the narrow event that you want to allow departure on. I mean, where the legislature done, they made a very, this is broad. This isn't limited to Romeo-Juliet circumstances, which is what you said. So this is broader. So what do we do besides our normal abuse of discretion standard?
I think in order to exercise the abuse of discretion standard, you do necessarily have to look at the entire record. And in looking at the entire record, it's the state's position the court abused its discretion. I don't quibble with the standard of review being abuse of discretion. However, I guess what I focus more on is what is substantial and compelling, and what has our case law defined substantial and compelling to be. And I'm not just narrowing that down to a Jessica's Law case, even though we're hearing a Jessica's Law case today. That's true of any type of departure, and that's where I guess the state is focusing its argument with regard to abuse of discretion is this truly the type of compelling set of circumstances that would force a reasonable person to go against the status quo and grant a departure? That's where the state primarily bases its argument. I don't feel that I ethically, based on case law, can argue with the standard of review. I accept what it is, and I understand how difficult that standard of review is. I understand the way the legislature wrote Jessica's Law statute, as well as its inclusion of mitigating circumstances that could or should be considered by the court before imposing sentence. But I guess I come back to what truly is substantial and compelling, which is the final determination the trial court really must make. Are these factors, even if I have found mitigating circumstances under 2146-43, are they truly substantial and compelling factors to depart based on the circumstances of this particular case and this particular defendant and perhaps this particular victim?
I want to go back to a question that was posed to opposing counsel, and it is not concerning the facts of this case. It's just trying to give the court guidance on how we would interpret the statute and, more precisely, what is allowed to be put into evidence at these sentencing hearings under Jessica's Law. Let me start with what appears to be pretty clean, and that is the statute says that mitigating circumstances can be basically admitted into evidence. Okay?
Yes.
I think that's a given under the statute, although it's not clearly articulated that way. And then it gives some examples of what those mitigating circumstances are. And because those are just illustrative and not complete and exhaustive, defendants are allowed to put on other types of mitigating circumstances. Correct?
I agree. Yes.
And then you, therefore, would be allowed to cross-examine defendants who would be testifying to that evidence.
Yes.
Correct? And what else would you be allowed to do on your own behalf? Could you put on testimony of the victim?
The state submits that it could put on testimony of the victim.
Is there any limit as to what you could put on to try to rebut that those are mitigating circumstances, or can you get into what appears to be more cleanly aggravating circumstances?
I don't think there would be a limit into the evidence that the state could present at a sentencing hearing in that regard. I think the state could properly get into any aggravating circumstances, or however you want to phrase that, or the circumstances of the case.
Okay,
I think the
so-
state could present that evidence.
So a lot of evidence mitigating and aggravating has been presented to the court at the sentencing hearing.
Yes.
And then I want to go back to the language that is in the statute when it says the mandatory minimum term of imprisonment shall be imposed, and then it's unless the judge finds substantial and compelling reasons following a review of mitigating circumstances. So I just want to find out your best opinion today. Is this a weighing of the aggravating versus the mitigating, or is it just receiving all the information and then saying, well, I'm reviewing only the mitigating circumstances, and I find that they alone are not substantial and compelling, or that they are alone substantial and compelling? I'm trying to figure out what district judges will do with all this evidence that comes in, and then how we review that.
Sure. I guess my position would be that in order to effectively consider mitigating circumstances, I don't want to use the term weighing, but you have to compare it to the circumstances of the case. You have to consider it in conjunction with the circumstances of the case.
It's what you call it. It's what you call it versus.
Right. It's semantics.
May I attempt to summarize? Oh, go ahead.
I was just going to ask, so the district court can consider the evidence you put on as aggravators,
I believe
Right.
so, yes.
but the finding would be limited to a review of the mitigating circumstances? That's what I'm having trouble with. So that's what the statute says.
I don't think, and this goes back to Justice Biles' question as well, I don't think the finding's limited to just the review of the mitigating circumstances. I think the review of the mitigating circumstances involves looking at the totality of the case as well. Because how can you determine if something truly is, mitigating to the point that it's substantial and compelling in this case unless you look at all of the facts in the case? And so, I guess we are phrasing it differently, whether we are weighing mitigators and aggravators, considering the circumstances of the case, considering the totality of the circumstances, whatever we want to call it. I think the district court necessarily has to engage in that type of procedure before an ultimate decision's made.
So why did the legislature in this statute not say weighing as it did in other statutes? What are they trying to tell us?
I think that they didn't include it because they didn't feel it was necessary, because we start at a sentence of 25 years to life. The death penalty, we don't start with death and work down. We work up in a death penalty case. So it would make sense that we would include aggravators and mitigators in that type of statute. In a Jessica's Law case, we work down. So I guess the state's argument or response in that regard would be there really would have been no purpose with regard to working down from the presumptive sentence of life imprisonment with a minimum mandatory of 25 years.
So the textbook journal entry for a district court after receiving all this evidence at the sentencing hearing would say what? What would be the minimum? I have reviewed the mitigating circumstances and find that that substantial compelling reasons exist to impose a departure period, and then we can say, well, that means the court followed the statute, and you have no quibble over whether the statute was followed, therefore there was no error of law.
But that's leaving out the analysis of whether it's substantial and compelling. And that's where the state's quibble here is that this wasn't substantial and compelling. I think the district court should indicate that it considered the statutory mitigating circumstances as required, but weighed it or considered it in conjunction with the totality of the circumstances, the facts of the case, and come to this conclusion. There are substantial and compelling reasons to support a departure, and these are my reasons. Because ultimately, that's where we have to conclude the analysis is, even though mitigating factors were found, are they truly substantial and compelling circumstances that force the judge to go against the status quo? I think that's where the analysis ends.
Justice Byron?
What I was going to do is just try to kind of refocus this back on Justice Lukert's earlier question and your response. The way, if I may attempt to summarize, you're saying that we can find an abuse of discretion here on at least two bases we've outlined in prior cases. That there is a lack of evidence, substantial competent evidence, to support the existence of substantial and compelling mitigators. So that's one way we could get there. It's not just about whether any reasonable person would ever agree.
Right.
And then another way we could get there is to say that the trial judge failed to make a correct legal determination of what substantial and compelling mean. Is that right?
Yes.
Okay, thanks.
I don't have any other arguments unless the court has any questions of me. If not, I would ask this court to reverse the trial court's departure in this case and affirm the decision of the Court of Appeals. Thank you.
Thank you. You're reserved 3 minutes for rebuttal.
With all due respect, I think opposing counsel is asking this court to be a fact finder. And the case law is clear. State v. Nelson, 291 Can 475. Repeatedly we've said appellate courts do not make factual findings even if records are sufficient to reach factual issues. Fact finding is not the role of an appellate court. The district court found the facts. The district court made a decision based on those facts. The district court granted the departure. The record supports the departure. And the only way an appellate court can reverse that is to find that not one other person in the entire universe would have made that same decision.
But doesn't the court have a responsibility to look at how the sentencing judge arrived at substantial and compelling? In other words, I don't want to use the word weighing, but the mitigating factors, and there clearly were mitigating factors here. And I think the question that Justice Beyer and Justice Biles asked basically, does that equal substantial and compelling? And isn't that our role to determine that?
Your role in terms of the substantial and compelling is, I believe the standard is substantial competent evidence to support the substantial and compelling.
Her decision that was met.
I'm sorry.
Her decision that
Yes.
that was met.
Yes.
And the content of that standard. I mean, I think that's where we ended with your opponent. And a lot of this is just what words were spoken to describe what occurred.
Right.
So acknowledging that. I think what I was suggesting is that the way I understand your opponent's argument is she's not just focusing on the would no reasonable person agree, but this idea that we also look under the broad heading of abuse of discretion as to whether there's substantial competent evidence to support the ultimate conclusion, or the ultimate factual finding, and if in fact that occurs, did the standard for what that finding was comport with our law? Right. And that's reviewed de novo. So, I mean, abuse of discretion is a little bit more complicated. We've recently acknowledged within the last 5 or 6 years that it's somewhat more complicated than just saying would right. every reasonable person, or would any reasonable person?
I would agree, but even under that, there's no lack of evidence.
Think there's plenty. I understand.
and there was no failure on the district court's part
on the matter
to make that. Yes,
I understand.
And I would just one last thing. Getting counted down here to 0 again. If this court does not agree with me, and this goes back for resentencing. Our case law is very clear, and the cases have all run together. It may be Spencer, but it may be another of the cases in the line of cases. It's very clear that the district court has the opportunity to find other reasons and make other determinations for a reason to depart. And so I just, if of course I'm asking the court to agree with me that the district court was correct, the Court of Appeals was wrong, but if it goes back, the district court has another opportunity.
We have no cases in which we found that the existence of a statutory illustrative mitigating factor was nevertheless not substantial and compelling as a matter of law. And that's what they're asking us to do.
Right,
Yeah.
right.
Was there any reason given or justification given once the departure took place? It seems odd, maybe, or inconsistent that the aggravated sentence was then imposed on the sentencing grid. Was there any justification or any explanation as to why that happened?
I don't recall that. You know, I don't have any recollection of that from the record. So I don't think so. My guess is I don't believe it's true, but I wouldn't hold myself to that. I don't think that was in there.
Counsel, before you sit down, I'll
Yes.
hit you with a question that'll hit you very cold, and if you don't have a response, that's fine. I was trying to think of an analogous situation in our criminal case law about how there is a legal standard that must be met, and then the review by this court is for abuse of discretion. And what I've come up with is a withdrawal of a guilty plea. It says pre-sentence it can be withdrawn for good cause
Good
shown.
cause. Mm-hmm.
And then this court reviews that determination for abuse of discretion. So drawing on that as a possible analogy, do you have any response, or do you want to say you're out of time and care to sit down?
The second avenue is the better one. Ask me it another way. And I'm not sure it's sparking with me exactly where you're going. I'm going to try to attempt to answer, but
Okay, a guilty plea has been entered, and then the defendant wants to withdraw the guilty plea.
right,
And the statute says it can be withdrawn for good cause shown.
right,
So that is what the district court looks at. Do I believe good cause has been shown by the defendant to withdraw the plea? And let's say that the plea is not allowed to be shown. There was no good cause shown, and there's an appeal by the defendant, and we are told to review that determination for an abuse of discretion by the trial court.
right.
And so I'm just wondering if perhaps an analog would exist between that situation and what we have here. Good cause being a legal standard such as substantial and compelling reasons, and then both determinations are reviewed for an abuse of discretion.
I'm trying to think because we certainly have many motions to withdraw guilty pleas. And the good cause, prior to sentencing. My recollection of the appellate cases in those is that we lose all of those cases because you do employ an
Defer.
abuse of discretion standard.
Because we defer.
I'm sorry. Yes.
Because we defer to the district court.
Yeah.
Unless there's been the wrong legal standard
Unless there's
applied.
been the wrong
Yes.
legal standard. Yes.
Right.
Yeah.
Which makes these two situations unique from other situations. For example, whether a confession was voluntary.
Right.
There's a determination made legally by the district court that yes, it was or was not, and we review that de novo and not for abuse of
Right.
discretion.
Right.
Okay. Very good.
correct.
Any further questions? Thank you.
Thank you.
Thank you both for the arguments this morning. The court will take this matter under advisement. This time the